assault instead of sexual assault of a child.
Well, the complainant was 17. Is that
Right here, the courtroom immediately takes on a chilling tone. The victim's pain comes forward, and the defendant tries to interrupt. Notice how the judge shuts him down quickly. Why? Because in these moments, it's about giving the victim her voice, not the offender.
that right?
Yes, sir.
No. Well, that's it. When 17
It
is
says does not apply on limitation on judge order, does not apply to 22011 sexual assault.
everybody agree with that? That so it's deferred or unadjudicated probation
Judge can't give him straight probation.
or flat prison time. So that's regular probation is not allowed. You're up section what? Yeah,
42A.054
of the Texas Code of
Code of Criminal Procedure. Yes, sir. Sure. Sexual assault. 22.
Here's where the legal maze begins. The judge references section 42A.054 of the Texas Code of Criminal Procedure. Translation: for serious crimes like sexual assault, the law bars regular probation, meaning the judge's hands are tied. What do you think? Should judges have more flexibility in these cases? Or does strict law protect victims better?
again 42A.1.
054.
Oh, that's what you said. No. Article 42A.53, which is the judge-ordered community supervision,
Right. Can't get
which is regular probation,
Right.
does not apply to, and we looked at section 22.011 Penal Code sexual assault, and that's
A8.
yeah,
What is sexual assault?
that is what was indicted in this case.
Yes, sir.
Go ahead on behalf of defense. You may go
Well,
forward, Mr. Deuceman,
thank you.
first. And
We are actually asking for deferred adjudication probation. I have spent quite a bit of time with Darrell concerning this, and he strikes me as a very sincere man who made a very, very stupid decision right before Christmas of last year. As the report indicates, they were having a Christmas party at his apartment with his daughter, a couple of other friends, and the first thing he did that was really, really stupid was providing alcohol for them. They were close to being of legal age, but not of legal age, and never should have done it. And that's the one beginning really stupid thing that happened. After that, he acknowledges that everybody drank way too much, including himself, that there's differences of opinions to exactly what happened. But frankly, he was pretty blacked out himself and doesn't even really recall the exact sequence of events. But he knows that something happened and something happened that should never have happened. He has told me that he totally accepts responsibility for this. He realizes
The defense leans hard on portraying the defendant as a hardworking man who made a poor choice. But notice the strategy here. Shifting focus from the crime itself to his responsibilities, job, and family. Classic defense framing. Humanize the accused, minimize the act. Does that argument hold up when the crime involves sexual assault of a minor?
that was about as stupid a thing as you could do. He's written a letter to the court acknowledging that responsibility. Looking at his history, he's never had any felony of any sort, even accusations of felony. He was on one misdemeanor probation, but that was an evading arrest. It really had nothing similar to this type of offense. He's a hardworking young man. He works a full-time job as an operator at a plant. He's got a bunch of children that he supports and pays child support on. Basically, what he's saying is this was just about as foolish a thing as anybody could do. He deeply regrets what happened. In the recommendations, he does say, I'm truly sorry for my actions. I never should put anybody in that situation. Learn my lesson. It should never happen anything like this again. Hardworking citizen who made a very poor decision. And I think that pretty well sums it up. Again, he's written a letter to the court that I've shown Mr. Laird as well. And if the court wants to address him or ask him anything else concerning it, I think I've kind of spoken to the heart of what you told me. He appears to me to be a very sincere man who is accepting responsibility for something that was horrible. And I think that he's asking the court to give him an opportunity to prove that nothing like this ever happened. You know. Have I pretty much covered that, Darryl? Do you want to elaborate or just wait and answer any questions that Judge has for you?
Let me just ask something here. Mr. Ardwan, did you want to say anything before the state? No? Okay. One of the things that helps us judges take care of our business is we get the pre-sentence report prepared by the probation office, and they do an outstanding job. I'm very proud to work with them. They help us greatly because there's a lot we don't know. Judges and the lady next door who handle these felony cases, there's a lot we don't know about. We weren't present. So we've got to make an important decision based upon information given to us in spite of the fact we weren't present. And we have to rely on certain methods, and we rely on getting your opportunity to be heard and listening to you. And then the probation office seeks information from law enforcement who do the investigation. And then most importantly, the complainant, the victim in the case. And then they prepare a pre-sentence report. And this one is 1, 2, 3, 4 pages. And it also has a supervision plan for the court to deal with. We have the indictment, probable cause affidavit, all these things that we look at, so that's really some of the first impressions that the judges get is preparing for this sentencing. Each party involved has a chance to speak. You, at your plea hearing, pleaded guilty to this offense that was indicted. Second-degree felony of sexual assault, which alleges that on or about December 22nd, 2024, in Jefferson County, Texas, you intentionally or knowingly caused the sexual organ of a 17-year-old young lady, to contact or penetrate your mouth without the consent of that young girl, 17. And that's what you swore to and pleaded guilty to. You understand? You were sworn to and you pleaded guilty. So when you go to the pre-sentence investigation, this is what you say. Even though under oath you had pleaded guilty to what the indictment elements were. You say, my daughter and her friends always come to the house. Everyone was drinking. The little accuser, you refer to as the victim in this case, my daughters went to get something to eat and she left her behind. We were intoxicated. Everyone was on the couch. She came, this is the victim, sat on the couch with me. We started fooling around with each other and I said, no, I'm not going to do that. She, the accuser, the victim.
This is the turning point. The judge calls out the defendant for giving 2 conflicting stories. One to the probation office and one under oath in court. And in law, credibility is everything. The moment you have 2 versions, both fall apart. Quick question for you. Should someone lose a plea deal the instant they're caught contradicting themselves?
Touched me. The defendant, you admitted to being under the influence of alcohol at the time of the offense and explained that you blacked out and don't remember what you did. That's your version, which was, it's her fault. That was what she did to me. But yet, under oath, in front of me, you had the audacity to plead guilty to intentionally or knowingly causing her sexual organ to contact and penetrate your mouth. Oral sex is what you did. That's what you pleaded guilty to. I don't see any of that admission in here. So are you lying to the probation office or lying to me when you pleaded guilty?
No, sir. That's exactly what happened. Like I said,
No, you have two different versions. Which one? They can't both be right.
When she says that because you were blacked out, you can't dispute that that's actually
yeah, I
happened.
can't. Yeah,
If that's what she said happened, it had to have
Yes, sir.
happened.
That's exactly what.
This is your version.
Yes, sir.
But when you looked at me in the eye and pleaded guilty, we went over all of this. You looked at me and said, I'm guilty of this. And you were under oath. You're under oath. It's a document that's swearing. You took the oath. You can't have it both ways, sir.
Judge, if I might, state of Texas is not satisfied that he's accepting responsibility for what he's done, and that offer was made upon him accepting responsibility. So we would at this time withdraw the offer and ask this be reset for trial.
Judge, I don't think that the state's offer was contingent upon anything, but I do say that he is accepting responsibility for this. He's saying that he was unconscious. He doesn't know exactly what happened, but he cannot dispute that that's what she says. He said, if that's what she says happened, that's what happened. I may not remember it because I was blacked out, but if that's what she says happened, then that's what happened. And that's the way he's related to me. I think that's
What do you have to say?
that's where we are. And I think the state should be bound by their offer.
The judge drives it home. How do you give back someone's innocence? You can't. This is the heart of victim impact in sexual assault cases. It's not about money, probation, or even time served. It's about irreversible harm. Think about that for a moment. Is there any punishment that truly balances this scale?
I think they have a fair issue that's brought up. You can't have it both ways.
He's accepting responsibility.
I'm accepting the responsibility, and I guess what I told her.
You're accepting responsibility, but you have two different versions.
I say I was drunk that night. I was out of here.
Who caused that to happen?
I did.
You have, voluntary intoxication is not a defense to any crime.
Yes, sir.
Okay. So that's your problem. You put yourself into it. But what we have here is a 7.
Finally, the judge brings up the defendant's prior criminal history, evading arrest. While unrelated to sexual assault, it paints a bigger picture: repeated bad decisions. In sentencing, this context matters. Judges don't just look at one act, but at a pattern. Do you believe past mistakes should weigh heavily on new crimes?
17-year-old who was sexually assaulted. Let me ask you this. How do you give that back to her?
Okay.
Her innocence.
Okay.
No. And you're responsible for that, the adult. I don't even know what the price, you can't set a price on it. But one other thing, here before this occurred in 20% point. In your pre-sentence report, you had an evading arrest or detention offense charged against you. It was a misdemeanor, and boom, you ended up being convicted on that crime. You were sentenced to 1 year in the jail. Then you were placed on probation for a year. That looks like it was extended for 18 months. Is that right?
Sir.
was it? Okay. It says
Still on
1 year jail, 1 year disposition, 10/9/23, 1 year jail / 1 year adjudicated probation and $1,000 fine, 10/1/24. And then semicolon, 18 months extension. I really don't understand what that means.
Are you still on probation, Mr. Mayor? You're off.
Yeah, I'm off probation.
When?
No, I get off probation like in February